And welcome to this Better Business Bureau webinar, Building Trust in Trying Times. I'm your host, Dale Dixon. So good to have you with us today. This webinar is a live service for BBB accredited businesses and will be recorded and replayed on YouTube and the various Facebook channels for Better Business Bureau. So with that, we're going to open up a quick poll question as we prepare for today's webinar. We'd like to hear about your status in receiving funding if you've applied for the PPP or the EIDT loans, anything regarding the stimulus package. So our team at BBB, both Jamie Dillon and Jason Kama, are working behind the scenes in that poll question. Watch for that to come up on your screen. We're going to make this as interactive as possible, where our guest today is going to present on how you process and work through the stimulus package once you receive your payment. And then we're going to open up for Q&A. What we would ask is that you, as a person who is participating in this webinar, if you would write your questions out in the Q&A box of the Zoom. Look at the bottom of your Zoom screen. You should see a Q&A. Go ahead and you can write the questions in there. I'm sure Darren is going to be answering most of those as he gets through his presentation, but is going to stay with us for this 30-minute webinar to answer those questions. Also, Better Business Bureau has a number of resources available to you. We're also going to post a link to our webpage where those resources are updated on a daily basis. You'll have links to all of the previous webinars that we have held 2 a week, and also a number of blogs and other posts and resources for you as a business to navigate these trying times. With that, I'm going to introduce our guest today, Darren R. Leong. And Darren represents clients in a wide range of employment and labor matters, including federal and state court litigation of wrongful termination, harassment, reasonable accommodation, breach of contract, non-compete agreements, other employment claims. He is also devoted the past 15 years to representing clients in those employment and labor law matters. Darren began his career in New York City, working for Fortune 500 companies in all aspects of employment and labor law. He now is in practice for himself and has been for the past year, working specifically in employment and labor law practice. And with that, Darren, so good to have you with us today. Thank you so much for making time for businesses throughout the United States. As far as Better Business Bureau is concerned, we really appreciate this. And I'm going to turn the time over to you for your presentation today.
Great, thank you, Dale. Hello, everyone. So I'm going to break up and talk first to those of you, because I see it's it's relatively split. For those of you who have not gotten a PPP loan approved yet, and then I'll switch over to those of you who have gotten your loans approved and are wondering about forgiveness. So for those of you who applied in the first round and did not get funded, a few updates on that. So the Senate passed the new bill. The House is expected to vote today. They are expected to pass new funding as well. And then that immediately goes to the president's desk, which is expected to be signed fast. What we don't know is how fast the SBA will open its portal back up, which is the point at which the floodgates will reopen and all the banks and lenders will be pouring loan applications into the system. Last time around, they gave a several days notice before they put it up. This time around, it could be anywhere from today to perhaps in a day or two, where they say, we're going to start the clock and open up the SBA e-trans system at this time. So you want to watch closely for when that happens. A few things: if you have an application pending at a particular bank, you should not feel shy about going to that bank and asking how deep in their line are you. And the question that I think is probably the most relevant one is, how deep is the bank's line in terms of how long it will take to process all the loans in front of yours, or the applications in front of yours, and get to you. Is it 1 day? Is it 5 days? Is it a week and a half? And you may have to be fairly persistent to get that answer. The second thing is you want to make sure your application is exactly perfect, because if it's going to be rejected in the SBA e-trans system for some reason, because there's something missing, or the address is wrong, or the certifications are not there, that application runs the risk of being set to the side while there's a big rush to get all the other applications in. So that second pointer would be, make sure that your application that's pending at a bank or lender is absolutely, absolutely perfect. I will just note also that for everyone, there's a new Q&A that just went up today from SBA and Treasury, which targets some of the larger employers who have gotten loans, but does address a big core issue, which is that in order to get a PPP, there's a certification that it needs to be necessary to support ongoing operations. And there has not been a lot of guidance for that out there, but the SBA's Q&A today is surely going to create some stir over it, because essentially what they said is, for businesses that are well capitalized, so the ones that have cash reserves through big public companies and that sort of thing, that they are suggesting that if you have a lot of cash reserves, you might not qualify under the necessary to support ongoing operations requirement. Whether that gets applied to down the chain to smaller businesses, et cetera, is completely unknown. It's an issue that we've kind of wondered about, but I guess essentially the update is the SBA did just open up that big can of worms today. I'll switch gears to PPP forgiveness, which for those of you who have got loan funds is clearly on your mind, because many of these requirements span the length of the 8 weeks after loan disbursement. So you want to know right now, not at the end of the 8 weeks, what you need to do. I've posted to the webinar chat, you'll probably need to scroll up to the top of it at right after 10 o'clock, a link to a public Google Drive. So our team has two memos that we have been updating regularly. The first is a memo for employers that I think we are on version 14, that talks about the general requirements of PPP, et cetera. For today, the memo on the drive that I'd put your attention to is the Forgiveness Memo. So we have a memo that we are updating that's specifically targeted to the forgiveness requirements. So feel free to take a look at that. That memo is broken down to what we consider to be the 5 core rules to maximize forgiveness of PPP. The first 2 rules, I think, go together or can be sort of read in conjunction with each other. So the first one is that in order to get forgiveness, you have to be using the money for an allowable use. That is actually a term under the statute, an allowable use. In the statute, that's defined during a time period that ends on June 30th. So there's some talk in terms of whether you can use funds before or after June 30th, or after June 30th. It's certainly possible that SBA and Treasury will issue some kind of rule saying that they think you can use it after June 30th. But until that time, I think the safe interpretation is that the statute says allowable uses end on June 30th. And so you should presume that the uses of the funds may be limited to on or before June 30th. Allowable uses, as you've seen from eligibility criteria and such, they include payroll costs, health insurance, retirement, leave payments, that sort of thing. You've probably heard quite a bit about the lists of items that qualify as allowable uses. So in the interest of time, I won't go into it in too much depth, other than to point out one thing, which is for higher compensated individuals or employees, the cap that can go towards an allowable use is an annualized $100,000 salary. So the max you can count toward PPP allowable use is that $100,000, but it's prorated because you're talking about an 8-week period. So you would take that $100,000, you would divide it by 52 weeks to get the amount of prorated per week. And then you would multiply by 8 in order to get what the prorated amount of that salary is for 8 weeks. That number comes out to 15,384 and change. And that is the limit. For employees, you can take that amount and you can tack onto it health insurance and retirement. But for owners, you are not allowed to do so. So just be aware that sort of that extra tack on of health insurance and retirement to get you above that annualized 100,000, that it will work for employees, but it is not allowed for owners who are essentially taking compensation, you know, on a draw or net profit basis, that sort of thing. The other piece of an allowable use that has gotten, I think, not that much attention is in the second interim rule. The SBA said that 75% of PPP funds need to be used for payroll costs. And I think a lot of people have overlooked, because earlier SBA essentially issued this 75-25 rule saying that no more than 25% of the forgiven amount may be used for non-payroll costs. This 75% rule that I just described actually differs slightly from the one that applies to forgiveness. So for clarity, the second interim rule explicitly says 75% of the money needs to be used for payroll costs, which means that as written, you should assume that whatever you're using the PPP funds for, whether it's forgiven or not forgiven, you should use it in that ratio of 75% or more for payroll costs and 25% or less for non-payroll costs. The second rule that we focus on is one that says forgiveness is for expenditures in the 8 weeks following loan disbursement. The biggest question on this one is what payments count, and the standard that applies is it's costs incurred and payments made. So costs incurred and payments made. Unfortunately, this is another term that Treasury and SBA has not defined yet. So the biggest questions are if you, for example, have work hours in the week prior to the 8-week period. So the actual work was done outside of the 8 weeks, but you pay it within the 8 weeks. Does that count toward forgiveness? And the answer currently is we don't know. We expect SBA and Treasury to issue guidance, particularly on this issue, hopefully by Monday. But right now we do not have an answer. That would be the same concept for things like prepayment of rent during the 8 weeks. If you're paying for rent several months down the road, but you're paying for it in the 8 weeks, does that count? That would also fall under this ambiguity where we just don't have an answer yet. Rules 3, 4, and 5, we look at them together as well. So rule number 3 is the rule that no more than 25% of the forgivable total forgiveness amount may be used for non-payroll expenses. What that ends up meaning is that in order to get forgiveness of the entire loan, you're going to end up needing to spend 75% on payroll costs. What that will mean for almost all employers is that in order to get to that 75% of your total loan amount to be used on payroll, you're going to be at full staff 100% pay, because that full staff 100% pay over that 8 weeks, assuming that it's similar to what your loan was based on, is going to be roughly 74 to 75%. So just be sort of aware of what that's going to require. If you do that, if you bring all of your staff back at 100% in order to meet the requirement that 75% of the total amount is used for payroll and 25% is used for non-payroll, it's really going to take the 4th and 5th rules out of the picture. The 4th and 5th rules, the 4th rule, for example, is that is a headcount rule. So it's a total headcount rule that says that you need to keep the same number of full-time equivalent employees for the 8-week period of your loan, of the forgiveness period, excuse me. You need to keep at least the same amount as a look-back period. And you have 2 choices for that look-back period. The first is the first 2 months of this year. The second choice is a February 15 to June 20 period last year. So essentially what you do is you pick one of those 2 periods that has the lower amount of headcount, and that's the amount of headcount that you need to keep over the 8 weeks in order to get full forgiveness. Again, if you are spending 75% of the total amount on payroll, you're likely going to meet this rule. The headcount is based on what's called a full-time equivalent. That is also probably one of the top 2 terms that have not been defined yet by the SBA. The last rule, number 5, is an individual employee pay rule, which says that you cannot reduce an individual employee's pay more than 25% compared to the most recent calendar quarter. So you're not allowed to drop them more than 25%. There's a couple of caveats to that. For those who have annualized salaries over $100,000, the rule doesn't apply. But again, for this rule that you can't take an employee and drop them more than 25%, it really should not come into play if you are attempting to get maximum forgiveness of the entire loan amount. Because again, if you are spending 75% on payroll of your entire loan amount, you're not going to be dropping anyone below 75% or more than 25% of what their normal pay would be. So I see Dale, I'm right at the 10:20 mark. So happy to stop here and then just take any questions that you want to toss out there.
Okay. So Darren, thank you so much. In an effort to be as efficient as possible with the questions and in recognizing Darren's valuable time, what we want to do, and our web participants valuable time is we have enabled upvoting on the questions. So as a participant, if you can go in and give a thumbs up to the questions that are most important to you, we have more than 100 questions that have backed up in our Q&A log. So we're not going to be able to get through all of them in the time that we have here today, but we want to get through the ones that are highest priority for our web viewers right now. So with that, go in, cast your vote on those questions that are most important to you, and then I'm going to read those questions off to Darren that have the highest votes. And right now, Sean Murphy's question, I got my cash this week, so payroll tracking starts next week. Sounds like the question is, when does payroll tracking start based on when the money comes in?
Yeah, it starts at disbursement. So it literally starts the moment the money is dispersed or the day the money is dispersed. And then the 8-week window for forgiveness runs from there. The biggest question that I'm sure you have is, well, normal payroll doesn't work that cleanly. Some of the days are going to fall in this, some of the payroll days are going to fall in the 8 weeks, some are going to fall out of the 8 weeks. And it's going to create some administrative hassle. The only thing we know for sure right now is that if the day is worked within the 8 weeks and it's also paid within the 8 weeks, that it's going to count. What we don't know, and hopefully expect an answer by Monday, because our reading of the statute is that the guidance is supposed to be issued by then. What we don't know is if the day was worked the week prior to disbursement, but you're paying it now in your 8-week window, whether that will count. One thing you could, at least at this point, plan on doing is for all the days worked in the 8-week period, you pay and plan at the very end not to have a lag between the last day worked and when the pay is given. So in Hawaii, you have 7 days to pay after the pay period, but you may want to just make a payment on the very last day. That said, I think it's likely the SBA issues some kind of gentler rule, but until they do, I mean, that's the only thing we know for sure.
Also important to note the fluidity of the times in which we live as far as the information coming in, the rules being defined, and what all of this means. Our next question, upvoted 64 votes, comes from Kenneth Block. What expenses are actually considered utilities?
Yeah, so utilities are payments for, payments under service agreements dated before February 15, 2020. So the emphasis is you can't just tack on something now. It needed to be sort of in effect a few months ago. But the utilities include electricity, gas, water, transportation, telephone, internet access. I mean, some of those are easy, like water or telephone, internet, that sort of thing. The one big question we get a lot is, what is a transportation utility? And the only guidance SBA has given is they said gas for a business vehicle counts, but they have not expanded beyond that.
Okay. Next upvoted question. In the case where an employee quits or is fired for cause, will that have an effect on forgiveness? If so, can a business hire someone else to avoid being penalized?
Yeah, so the short answer is yes. So the rule that applies here is the headcount rule, which we just label as rule number 4. Which says that you need to keep the average monthly number of full-time equivalent employees. It does not say you have to keep the same ones. I guess my caveat to that is it leaves open a little bit of potential mischief. And as we've seen to your point earlier, Dale, we've seen a very, very expansive and liberal rulemaking coming out of SBA and Treasury. I mean, some of the rules that SBA and Treasury have issued are quite frankly plainly contradictory to the statute. Other rules completely are made up, like the 25%, 75% rule appears nowhere in the statute. It's completely made up. So, you know, I go on this with sort of the guiding principle of, if it seems a little bit like mischief, then you might want to just stay away from it, even if there's no overt prohibition now. And so the mischief is, I don't like this employee, they were junk, I already laid them off, I don't want them back. But to get my head count up, I'm going to hire my brother, my mom, and my sister. And as a technical matter, there's nothing in the statute that prohibits that. But as a practical matter, I would be very worried about doing something like that. So that's a long answer to a short question.
This might be on the verge of mischievous then. Can you give bonuses to add to payroll costs?
Yeah, I mean, this is another one that appears to have a necessary and required piece to it, but could also kind of go off the rails. So in the first interim rule, the SBA and Treasury actually did some math on their 75%, 25% rule. And if you're required to use and expected to use a full 75% of PPP funds for payroll costs, if you bring everyone back at 100%, you will probably still fall short of 75%. You will probably end up right in the 74-ish % range, which means the only way that you could get to 75% is to pay a bonus or to add another employee on. So for that reason is why I think that, you know, sort of reasonable bonuses or bumps in pay probably will be allowed. And, you know, especially if it's kind of business justified. For example, you know, working hazard pay during COVID, that seems like a valid justification for a bonus rather than just, you know, a bonus for no reason. So, you know, the front end of that answer is that bonuses are actually probably required for many employers in order to get to 75%. The mischief on the back end of that is, you know, crazy bonuses that look like it's just funneling money a certain direction don't work. I think there is some already built-in protection, which is that for owners, you know, owners are capped on the amount of pay that they can funnel toward themselves, and it's capped at what, you know, essentially the rate of pay that they got last year. So the part where I would be very concerned would be where an owner, you know, essentially bonuses themselves or someone, you know, with similar interests in a manner that pushes their pay up beyond what it normally otherwise would have been. I would be less concerned if it's going straight to, you know, line level employees for hazard pay and that sort of thing.
Okay. Alyssa wrote, and 37 people added on, can you repeat what you said about owners who take payments as draws? Can that be included in PPP funds and forgiveness?
Yeah, so apologies for rushing through that. So the first thing I would say here is a very detailed description relating to sole proprietors, owners, you know, LLC members, that sort of thing, is in the second interim rule. And don't let that term scare you. It's actually reasonably well written for you know, a non-lawyer to read. The place where you find that is you go to home.treasury.gov. I think that's the homepage for the Treasury. At the top, there's this kind of red hyperlink towards the top of that first page. If you click on that, the next page then has a list of all the Treasury's resources. So the resource that you're looking for is the interim final rule that was issued, I think, on April 14th or somewhere around there. And that one talks very specifically about this. But essentially the highlights are this. Owners are one, capped in pay. So you cannot go above the $100,000 annualized. And you cannot, if you are at that $100,000 limit annualized pay, which comes out to the forgivable amount for that 8 weeks being 15,000 and change. You cannot, for that owner, count health insurance and retirement on top of it. The other restrictions are things like if you didn't have a certain utility or other type of expense last year, then it's going to be disallowed to just add it now. And actually, I should correct that. I shouldn't say utility. I should say things like health insurance or retirement. So for example, if you're an owner or a sole proprietor and you didn't have a retirement account last year, then the rules talk about not starting one now and then using PPP funds for forgiveness of that, because that would essentially be considered a windfall. And in terms of the pay that you can apply to an owner, the rules also say that if you, for example, made $50,000 last year net profit, don't treat yourself during the 8-week period as if you're making $100,000. It needs to stay at that last year's level. Again, all of those rules in that second interim final rule, they're really directed at trying to stop folks from giving them more than what their previous kind of compensation would have been. And that's because for owners, members, that sort of thing, oftentimes they're paid as based on net profit, which is mushier than going just based off of a W-2.
Okay. Helene asks, telephone costs. Is this only landline, or can this be landline plus cell phone, or only cell phone? That's the only phone that the business owner has.
We presume it's both. In terms of a utility, that's a telephone utility. I don't think there's a distinguishing feature between a landline or a business line or a mobile phone.
Okay. The question, what about 1099 employees?
Yeah, so a 1099 employee is a what's the term? It's a contradictory term, right? There is no such thing as a 1099 employee. So a 1099, as a technical matter, goes to an independent contractor, versus a W-2 goes to an employee who's paid wages, right? And the major distinctions in how they're treated are, employees fall under the employer, and the employer is taking out withholdings or taking out Social Security, Medicare, et cetera. An independent contractor who is given a 1099, on the other hand, is technically considered to be a totally separate entity. And that entity has its own ability to file for its own PPP. And also that entity, if it has employees and that sort of thing, those employees fall under that entity. So, fully realizing that this is one of the areas in sort of the normal world that get blurred because people are often treated as independent contractors when they probably should be treated as employees. This is not a time to start treating those contractors as your employees so that you get the benefit in PPP, but then essentially take another benefit in how you've treated them normally. If they're on 1099, you should presume that they are an independent contractor and can file their own PPP.
Perfect. There's no context with this, so I'm going to give you the time the question was asked. It was 14 minutes past the hour for your presentation. Gross payroll or net payroll?
So the answer is sort of, and this relates to which taxes, which employment taxes count. Okay, so on this one, I'll also point to the first interim final rule, which is on that same website, that Treasury website, which I think was issued around the early April, but it's labeled as Interim Final Rule 1 on that website. And there's an example in that one, I believe, either there or it's in the Q&As. But what you're allowed to do, what you're allowed to do is count the federal withholdings for the employee side. So Social Security and such, that is the employee's share that the employer normally takes out, that's counted in. So that counts as payroll costs. What you're not allowed to count is the employer's share. So for example, if the employer is paying $4,000 in wages, but what the employee is actually getting in their paycheck is, $3,000 because a bunch of withholdings were taken out, you can count the $4,000. What you cannot count is that you had to pay an extra tax on top of that $4,000 for the employer share of federal payroll taxes.
Our next question from Andy: how do you show proof you used it on what payroll?
Yeah, and so the rules have not given a lot of guidance yet, other than to say you will need the records to justify the payment. So if it's payroll, for example, then I think the payroll records or the checks that were made, that sort of thing, would be the kind of documentation that you're going to want to keep. If it's rent, you're going to want to have a copy of the check of the rent that was paid, and maybe an invoice for what period it was for. So essentially the most official documents that show that the expense was made for an allowable use in the correct time period. The process that is going to happen is the borrower is actually required to go to the lender and say, I want forgiveness. So don't expect your bank just to come to you at the end of the 8 weeks. You actually have to go to the bank and say, hey, I want to apply for forgiveness of my PPP. The banks are in the process now of creating their procedures, and they will have 60 days to process your forgiveness request.
Our next question: employees who are on payroll in first and second quarter of 2019, but quit or were let go in late 2019 or early 2020, not intended to be replaced due to changes in the business, do they have to replace these number of people in order for the forgiveness of PPP to work? Or is there a way to explain the changes in business that explain why the number of employees is down from last year as a whole?
Yeah, so to the extent this applies to what we call rule number 4, which is the headcount rule, you would have to meet it. I think that the reason why you have 2 choices of a look back period for headcount, you have the first 2 months of this year, or you have a period that is, about a year ago. So the February 15 to June 20 period last year. The reason why you have 2 choices and can pick the lower headcount is because, there's a realization that some of this kind of thing of employees quitting or that sort of thing is going to happen. So they wanted to set a headcount standard that is reasonable, but whatever that headcount is, that full-time equivalent headcount, whether it's the first 2 months of this year or it's that time period of last year, you will have to meet it.
Okay. I'm going to remind our webinar attendees that we're enabling upvoting on the question. So if you read through those questions and see a question that you really want answered, go ahead and click the thumbs up on that. It helps us in this case because there's no way, we have over 200 questions that are waiting to be answered. And I can tell you that we're just not going to be able to get to all of them today. And then go ahead, Darren.
Sorry, Dale. I was just going to tack onto the last answer, but go ahead.
Okay. Also, I will ask that you grab a hold of the Google Docs that Darren is making available, those are updated on a regular basis, correct, Darren, with the latest
Correct.
information to answer those questions. So I'm going to let you go ahead and tag on the answer to the last question, and we've got the next question queued up and ready to go for you.
Sure. So with respects to what we call rules 4 and 5, so the headcount rule and the individual employee reduction of no more than 25% pay rule, there is what people are calling an exception or a safe harbor, that sort of thing to that rule. And the way it's being described, at least in some of the articles and what's going out, is that rules 4 or 5 don't apply if by June 30th the business brings back either to the February 15 level. They bring back the headcount that was in place at that time, or they bring back wages up to at least 75% by June 30th. To me, there are two real big unanswered problems with that quote unquote safe harbor. The first is that it's written in a section of the statute and in a manner that is probably the poorest drafted portion of the entire statute. It is incredibly difficult to read. And so it does appear to say, hey, you could just bring everyone back on June 30th, and as long as you do that, you're fine. But that has inherent to it two major problems. One is I just highly doubt that Congress intended to set a rule where you could just bring everyone back for one day on June 30th and then fire them on July 1st. Because there's no kind of limitation in that rule on you have to keep them around for a certain amount of time. So if the rule means what everyone is sort of saying it means, then that to me is a very peculiar kind of result. And so I hesitate there. The second is that in order to meet the 75-25 rule of using at least 75% of the funds for payroll costs and the other 25% for non-payroll costs, you're going to have to bring everyone back for the 8 weeks. So if if you're thinking, oh, I'll be so smart and get around rules 4 and 5 by just, waiting to the very end and bringing everyone back on June 30th, you likely will not be able to use very much of the money for forgivable purposes. So, as a practical matter, again, rules 4 and 5, they get swallowed into rule number 3 if you are using the money, 75% for payroll and the other 25% for non-payroll.
We are a single member LLC filing as an S Corp. Are you saying the health insurance for the owner is not an allowable expense?
It would be if it keeps you under that $100,000 cap. But if it's going to take you over that $100,000 cap, then yes, it would not be allowed.
We received the PPP loan in full, exactly what we submitted for. Then a week later, we're also awarded and deposited into our account the EIDL $10,000 advance. I was under the impression that the EIDL would come before the PPP funds and that it would reduce the amount of the PPP loan by the $10,000, but we got both.
Yes.
Okay, go ahead.
Go ahead. We were expecting the EIDLs to come faster too, and I think that was the intent. I believe there's actually a requirement for the grants or advances to be funded in 3 days. That I think was just not feasible. I mean, SBA processed something like 14 years of loans in 14 days. So as a practical matter, EIDL has gone much slower than PPP has. You are correct, though, that that $10,000 grant or whatever the amount is of the advance is going to reduce the PPP forgiveness by that amount. So there's no double sort of counting there.
So the person who asked this question, Tommy, needs to hold on to that $10,000 to repay the PPP loan.
Yeah, so that $10,000 advance, yes, you would keep it, but just know that in the forgiveness, when you apply for forgiveness of the PPP, say your forgiveness amount is $20,000, you're going to have to subtract the $10,000 of the idle grant. So your forgiveness will be 20,000 minus 10,000,
Okay.
that sort of thing.
This is the next part of Tommy's question. Regarding forgivable rent expenses, is common area maintenance included as a forgivable expense, or is it simply the base rent?
Yeah, we've tackled this one a few times, and it depends on whether CAM is defined as rent, because there's no other guidance on it. I mean, the best I could find is some, internet definitions of CAM that say it's a component of rent, which would be a good faith basis to include it. But, as a technical matter, SBA and Treasury have not specifically said whether CAM counts.
And the third part of the question that was upvoted regarding forgivable payroll expenses, are the fees that a payroll service charges per payroll per employee forgivable, or is that just the actual payroll numbers?
Actual payroll numbers.
Okay. Teresa's question, upvoted 29 times. What part of the federal payroll taxes are included?
Yeah, so again, so the example would be if, say, there's $4,000 in gross wages, and there's the employer side and the employee side of federal employment taxes, right? Medicare and Social Security. So the employee half of it counts toward the payroll costs. So essentially the full $4,000 would get counted, even though the employee side in what they get in the paycheck will get taken out, and they'll get something like 3,000 something. What you cannot include in payroll costs is the employer portion of those Social Security and Medicare. I'll tack on to the answer that each state also is taking its own stance on whether this money is taxable, both under the general excise tax and as income. So we pushed this to the Hawaii tax authorities. We've gotten sort of an informal comment that they think it will likely end up being state income tax, but they don't know whether it's GET qualified. I think that's an unofficial position, so we really still don't know. But it's just something, it's something to keep on the radar in terms of, calculating the benefit to you of the money. The other, I'll digress for a second. The other sort of weighing the actual benefit of the money is that, just remember again, so if you are paying the payroll costs out, that employer side of the unemployment tax, you're going to have to bear it, and it's not going to be forgivable. And then there may also be some other like workers' compensation, TDI, that sort of thing, that you will end up having to pay. So, if you're calculating, the benefit of bringing an employee back, you will need to keep that in your head.
Okay. Are copier leases included under rent?
Not so. I don't think it's under the rent provision. The question is, I think, more whether it qualifies as a utility.
Okay.
So the examples have been things like telephone, internet, that sort of thing. Copiers really seem quite close to that, but without having sort of a specific reference toward it, it definitely seems like a utility to me.
I have an employee that was only laid off for 6 days and declined to return when asked to come back. She's drawing unemployment, and I have been unable to get anyone on the phone to ask what I need to do.
Yeah, so this one, this was a big fear that is coming to fruition in less degree now, but so the federal unemployment adds a $600 sort of add-on to state unemployment, and it goes through July 31st. What that means is if the employee is actually getting the unemployment check, which in our state is, it has not really been happening yet, but probably soon will be, is that the employee is going to make more on unemployment than they would at full wages for many sort of lower paid employees. And so the fear for employers is that the employees won't want to come back. They want to stay on unemployment. The big sort of missing piece to that is if an employer offers the employee 100% wages and hours to come back, the employee will likely forfeit. And in Hawaii, we are quite certain that they forfeit the entitlement to unemployment, because essentially the requirement for unemployment is that you have to be available and willing to take on work. And if work is offered to you, employee, and you decline it, then you forfeit the eligibility for that unemployment. So what the employer can think about doing is, and many unemployment offices already ask for this information, is writing to the unemployment office and saying, I made this offer to the employee to come back at 100% wages and hours, and they declined. And that almost certainly will end up meaning that they will not qualify for unemployment. The tag on to this, and we've actually bounced this question on some webinars off of our congressional leaders, is that I really think that what Congress was doing here is making a determination that they're going to subsidize workers, but is it better to do it through payroll, or is it better to do it through the unemployment system? And the clear determination is that it's better to do it by having employees on payroll, because when it's time for the economy to get back up and to get rolling again, be back in business, the data is very clear that it's much easier to get people who are already on payroll back working than it is to get someone off of unemployment. So, that's just a sort of a commentary on, I think, what the intent was.
Let's see. Kevin asks, and it's been upvoted 24 times, what about businesses that are prohibited from work, like residential construction? If you get money before the governor lifts restrictions, is the start date still at disbursement?
Yes, it's still at disbursement. So this raises the other really big kind of awkwardness about this program, and something that we have pushed very hard on, which is for businesses like that, or restaurants, retail, businesses that are essentially shut down. If you do what the law is telling you to do and you bring everyone back at 100%, your full staff, many of them are going to be underutilized. So, and paid to do essentially very little. And that feels very awkward for a business. So, we think that is what the law has incentivized employers to do for a whole bunch of reasons. One is that the interim rules specifically talk about restaurants, retail stores, shopping malls. They had gyms in there on the same level of the other ones, and say that those businesses are closed right now, and here's how they can benefit from PPP and use 75% of the funds. So, the government agencies are essentially saying, look, we know you're going to be closed. We're telling you to put these people back on payroll, and we understand that you're going to be closed. So based on that, we do think that the forgiveness is intended to include businesses who are essentially going to be paying employees to do very little. One thing that we've sort of rolled out, at least as an idea to consider, is, don't just think of them as paying people to do nothing. There are creative ways to advance your business that are a little outside of the box. So the first is, you can do training and other things, marketing, social media, stuff that you wouldn't otherwise have had time to do. But you could also utilize that labor for community service projects and other sort of community benefit things, where you would get an advertising and marketing benefit out of it, notoriety in the community for all the good work your employees are doing. in the process, do good for the community, and then actually use the labor because you have it. So for example, for a restaurant, you could, if you are only doing takeout now, after looking at your workers' comp insurance and car insurance, you could have workers doing deliveries. Maybe those deliveries are for free. Maybe some of the food that you're now producing, because your labor is essentially free, can go towards some of the food pantries or other nonprofit organizations you could team up with to help them with their efforts to provide meals to senior citizens and that sort of thing. So I really do think that if you look at that big pool of labor, which in Hawaii is $1.5 billion of labor that's flooding back into the market, there are real opportunities here for businesses to get people back on payroll, to advance the business in terms of its stature in the community, and to do good works in the community at the same time.
So I'm going to ask for a lot of grace from our webinar participants in that we have over 236 questions. We have a hard left to answer, I should say. We have a hard out at the top of the hour. It's we're coming up on 11 a.m. Hawaii time, where Darren's at 3 p.m. Mountain time. So just please understand our limitations as far as this webinar is concerned and our ability to answer all of the questions. We are going to be sending out a link to this webinar so you can go back and listen to the fantastic information that Darren has shared with us, and also give you the links to this. And Darren, if there was one resource, I don't know if it's provided by the SBA, where you would point people to get the most up-to-date information, those especially that haven't had their questions answered, where would you point people for that resource?
Yeah, I would point two places. The first is that Treasury website, home.treasury.gov, and then navigate to the page where they update all of their Q&As, interim final rules, etc. That stuff may be a little thick for some people to navigate through. So the second place I'd point to is our public Google Drive that I had posted on the chat, which has the most current version of both of our memo for employer and the forgiveness memo.
All right. And with that, we've got a little over a minute and a half left. So I'm going to ask the last question of you, Darren. What if you do not use all of the monies received for payroll, rent, utilities, interest? Can you use it for other expenses?
Yeah, so I'll try to answer this one really fast, because this has been a subject of debate. I think that the statute is very clear that June 30th is the end date for allowable uses. And if there are no other allowable uses of the money, then presumably you'd have to give it back because you're not allowed to use it past June 30th. The caveat to that is you could definitely see a situation where SBA or Treasury changes that rule, and maybe they provide clarification on it soon. So the takeaway point is, I think it's very risky to think that you will be allowed to use the money after June 30th. But it's certainly possible that SBA or Treasury issue a rule and say something to the contrary.
All right. With that, Darren Leong, thank you so much for taking this 30-minute webinar to a full hour, answering a lot of questions for folks that were top of mind. We really appreciate you taking this time with us today and are incredibly grateful to our viewers. Again, our apologies for not being able to get through all now 244 remaining questions, over 250 questions asked during this time, but obviously we hope you understand the limitations of time on this and resources that we have to answer these questions. We're going to be sending an email to all of the registrants that will have a link to this webinar to go back and rewatch and to share with others. In that email will be links that, all of the links that Darren has noted, along with a link to an upcoming webinar where we will be answering more of these questions. And that's going to be on Tuesday. I believe that is April 28th off the top of my head, but that's going to be Tuesday, same time, regardless of where you're at. That'll be 10 a.m. Hawaii time to 2 p.m. Mountain time, that we'll be answering more questions on the stimulus programs, PPP, the idle loan, all of those that are coming up as we have answers to those. So another great webinar for you coming up Tuesday. The link to register for that webinar is in the chat box of this webinar. You can get it there. Also on the front page of our COVID coverage that is also widely available. So with that, Darren, thank you so much. We are past time. We appreciate you. We appreciate all of you who joined us for this webinar, and thank you for understanding our limitations and answering these fantastic questions. Have a good day, and definitely go out there and find the information. Thank you.